Hello, everyone. Have you ever found yourself in a situation where you signed a lease agreement, but the tenant unilaterally terminated the contract early, giving very little notice, causing damage to the landlord? In business, this situation is quite common. And the precedent number 21 of 2018 from the Supreme People's Court has guided a typical case, helping to determine who is at fault and who should be responsible for compensation in this case. On April 10th, 2006, limited liability company D signed contract number 1141 with Joint Stock Company C. Accordingly, Company D leased two steel-hulled locomotives and towing equipment for ships entering and leaving ports 10 to 10 and Kide Quang Ninh. Duration: from the date of signing until December 31st, 2006. Rental price: 50 million VND slash month slash locomotive. Fuel costs to be paid by the lessee. Personnel to be arranged by the lessor and fully paid. The contract does not specify conditions for early termination, and in the initial months, everything proceeded normally. By August 17th, 2006, Company C sent a notice of termination of the contract effective August 20th, 2006, citing the reason of no longer needing to lease two locomotives. The gap between the notice and the termination of the contract was too short, preventing Company D from finding a replacement contract, resulting in financial losses. This was a critical step, as the unilateral early termination of the contract created clear legal consequences. Immediately after, Company D requested payment for the remaining lease amount from August 21st, 2006 to December 31st, 2006, totaling 403 million VND, along with late payment interest. Company C only paid a portion and disagreed with the remaining amount, claiming it was not accurate. Due to the inability to negotiate, Company D was forced to file a lawsuit on March 18th, 2007, requesting the court to resolve the remaining amount and protect its legal rights. At the first instance court, the request of Company D was not fully accepted. The appellate court rejected the appeal due to being out of time. However, the Chief Justice of the Supreme People's Court filed a cassation appeal, annulled the first instance judgment and the appellate decision, and sent the case file back to the Quang Ninh Court for retrial. This emphasizes that the right to actual compensation is always protected by law, and the lessee cannot circumvent the law by unilaterally terminating the contract without agreement. The Council of Judges stated, the contract does not have an agreement on the conditions for early termination. The lessee provided a notice that was too short, causing damage to the lessor. The fault lies with the lessee, and the actual damage is the rental amount for the remaining period of the contract. Legal principle: anyone who causes damage by unilaterally terminating the contract must compensate, based on Article 426 of the Civil Code 2005 and the regulations on commercial contracts. Case number 21 reminds us of a simple yet important principle. The party causing damage due to unilateral termination of the contract must compensate, and a clear contract will help protect the interests of the parties in commercial relationships. If you find this video helpful, please share it so that more people can know about it and refer to it. See you all in the next videos.